Today we'll discuss one of the most consequential and misunderstood areas of education law that you'll encounter as an educational administrator, the constitutional distinction between counterspeech and the heckler's veto. This is the kind of problem that lands on your desk when a parent calls the superintendent to demand that you cancel a student-organized event, when students stage a walkout over a guest speaker, or when a community member threatens to show up with 200 people to protest a panel discussion your school has approved. The pressure in those moments can be enormous. Every instinct you have as a leader will push you toward cancellation, suppression, or silence. But in many of those moments, the legally correct decision may be to do the opposite. You are not only administrators, but also constitutional actors. Public schools are government institutions, and when you exercise authority over student or community expression on school grounds, you act as agents of the government. The First Amendment constrains what you can do, even when political pressure and emotional intensity point in the same direction. So the questions are, when does your response to controversy protect school safety and educational order? And when does it become an unconstitutional surrender to the loudest voices in the room? The First Amendment prohibits the government from abridging freedom of speech. Public schools are government institutions. You, as a principal, assistant principal, or school district administrators, are government officials for constitutional purposes. The First Amendment applies to you as a constraint on the power you can exercise. The landmark case is Tinker v. Des Moines Independent Community School District 1969. The Supreme Court held that students do not shed their constitutional rights at the schoolhouse gate, but the court also recognized that schools have legitimate interest in maintaining order. The key requirement is that schools must demonstrate that student expression would materially and substantially disrupt school options before they can suppress it. Mere discomfort, controversy, or disagreement is not enough. The school must point to concrete, demonstrable disruption or a reasonably foreseeable disruption of the same kind. Veto School District Number 3 v. Fraser, 1986, permitted schools to regulate vulgar or plainly offensive speech. Hazelwood School District v. Kuhlmeyer, 1988, gave schools broader control over school-sponsored speech when editorial decisions were reasonably related to legitimate pedagogical concerns. Morse v. Frederick, 2007, permitted schools to restrict speech reasonably interpreted as promoting illegal drug use. Those cases established the framework. Students retain their First Amendment rights in school, but those rights are not absolute. Schools can regulate speech that is substantially disruptive, vulgar, pedagogically inappropriate, or promotive of illegal drug use. What schools cannot do is suppress speech simply because the ideas expressed are unpopular, controversial, or offensive. That prohibition on viewpoint discrimination is the constitutional bedrock on the difference between counterspeech and Heckler's veto. Counterspeech is the use of more speech to oppose, criticize, or respond to expression that one finds objectionable. Justice Louis Brandeis articulated this principle most famously in his concurring opinion in Whitney v. California, 1927. Brandeis rejected the notion that the government should suppress speech merely because it's controversial or potentially harmful. He argued that the appropriate response to dangerous ideas is public discussion rather than censorship. As Brandeis wrote, if there be time to expose through discussion the falsehood and fallacies, to avert the evil by the process of education, the remedy to be applied it's more speech, not enforced silence. This statement captures a fundamental principle of the First Amendment. In a democratic society, open debate and counterspeech are generally preferred over government suppression of expression. In a school context, counterspeech can take many forms: petitions, armbands, signs, flyers, rallies in designated areas, letters to school newspaper, or silent protests during an assembly. They all are generally protected under the First Amendment, provided they do not materially and substantially disrupt school operations. Counterspeech is characterized as reasoned argumentation, parallel protests in designated areas, and civil disobedience in which actors accept consequences to highlight injustice. They are the hallmarks of constitutionally protected expression, which is speech that responds to speech without extinguishing it. The heckler's veto is fundamentally different. It occurs when the school administration suppresses a speaker's expression, not because the speaker has done anything wrong, but because the audience's hostile reaction has created a threat of disruption. The government silences the speaker to appease the crowd. The term heckler's speech captures a specific constitutional danger. If the government can shut down speech whenever listeners threaten disruption, then the most intolerant members of any audience effectively hold veto power over public expression. The heckler's veto can take many forms: coordinated shouting designed to drown out a speaker, physical obstruction, and conduct designed to permanently silence the speaker. The constitutional problem arises when the administration responds to this behavior by canceling the speaker or punishing the speaker rather than the disruptors. That response grants the disruptors exactly what they wanted: the suppression of speech they opposed. Time, place, and manner restrictions are your most important regulatory tool. They allow you to manage when, where, and how speech occurs without controlling what is said. Those restrictions are constitutional as long as they're content neutral, narrowly tailored, and leave open alternative channels for communication. You cannot use them as a pretext for suppressing a particular viewpoint. Viewpoint discrimination is the suppression of expression because of the specific opinion or ideology expressed. When you suppress speech based on the viewpoint, the court applies strict scrutiny, which is the highest standard of judicial review, and requires the government to demonstrate a compelling interest and a narrowly tailored means of achieving that interest. And viewpoint discrimination almost never survives that level of review. Prior restraint refers to government action that prevents speech before it occurs. Prior restraints carry a heavy presumption of unconstitutionality. If you cancel a speaker before any disruption has occurred solely because you anticipate controversy, you bear an especially heavy burden of justification. Here is an example. Your school has approved a student-organized panel on immigration policy. A group of students who oppose one of the speakers plan to stand outside the auditorium with signs and distribute flyers. This is counterspeech. It adds voice to the debate without preventing the event. Now let's change the facts. The same students plan to enter the auditorium and shout over the speaker, bang on a wall, and block the entrance. This is no longer counterspeech. This is obstruction that materially and substantially disrupts school operations. If you discipline the disruptors and protect the speaker's right to be heard, you have upheld the Constitution. If you cancel the event before any disruption occurs because you anticipate negative reactions, you have enacted a heckler's veto. You have allowed the anticipated hostility of the audience to determine which speech is permitted. Think about this from the perspective of the students who organized the event. They followed every rule. Their event was shut down because other people objected to the message. What lesson have you taught those students about democratic institutions? Most Hecklers veto situations in schools are not created by administrators who consciously intend to suppress speech. They are created by administrators who default to the path of least resistance. The mechanism is consistent. Speech generates a hostile reaction. The hostile reaction creates an administration problem. The administrators solve the problem by eliminating the speech rather than managing the reaction. This mechanism is powerful because of the unique pressures school leaders face. You answer to a politically responsive school board. You serve families with diverse views. You manage an organization in which any disruption can cascade into safety concerns, learning loss, and reputational damage. The rational organizational response is to avoid risk, cancel the event, silence the speaker, prohibit the demonstration. Each decision taken individually may seem defensible, but taken together, they establish a pattern in which the school favors silence over expression and audience comfort over constitutional rights. Consider the cumulative effect. A student wears a political shirt. You tell the student to turn it inside out because another student complained. A student group wants a moment of silence for a cause. A parent objects, and you deny the request. In each case, you rewarded the objector and penalized the speaker. Over time, you have created a standing Heckler's veto. Public schools are one of the few remaining institutions in American life in which people from different backgrounds and different beliefs are required to occupy the same space. They are democratic institutions in the most fundamental sense. They serve everyone regardless of ideology, identity, or political affiliation. When school leaders suppress speech to avoid controversy, they undermine that democratic function. The signal that the institution will protect the comfort of the majority or the most vocal minority at the expense of dissenting voices. They teach students that the way to handle disagreement is to silence it. Over time, those lessons accumulate. They shape institutional culture. They determine whether a school is a place where ideas are tested and debated, or a place where certain ideas are permitted and others are not. The Heckler's veto has deep roots in Supreme Court precedent. In Forsyth County v. Nationalist Movement 1992, the court struck down a permit fee scheme that charged higher fees for demonstrations likely to provoke hostile audience reactions. The principle translates directly to schools. You cannot impose greater restrictions on speech because you expect a negative audience response. In Terminiello v. City of Chicago 1949, the court held that the function of free speech is to invite dispute, and that speech remains protected even when it provokes anger. For school leaders, this means that the audience's emotional reaction to speech is not by itself a constitutionally sufficient basis for your suppression. The Constitution requires you to protect speech even when it generates controversy. Your authority to regulate disruption does not extend to regulating ideas. The legally correct response to a hostile audience is to manage the audience, not to silence the speaker. Of course, the real world of school leadership is full of gray areas. What do you do when protected speech targets a vulnerable student population? And what do you do when a student's legally protected protest causes psychological harm to others? There are 3 practical guidelines that can help you navigate those gray areas. First, always ask whether your decision would be the same if the viewpoint were reversed. If you would cancel a conservative speaker under identical circumstances, would you also cancel a progressive speaker? If the answer is no, your decision is viewpoint-based and will not survive legal scrutiny. Second, document everything. Write down the specific concrete basis for your decision. What disruption you anticipated, what evidence supported that forecast, and what alternatives you considered. Third, consult before you act. Call your school district's legal counsel. Create a paper trail that shows your decision was deliberate, informed, and grounded in identifiable concerns rather than political pressure. The distinction between counterspeech and the heckler's veto is a test you'll face repeatedly. You'll face it when a student says something that offends the community, when a parent demands that you silence someone, when a school board member suggests that discretion is the better part of the valor, and when every political signal tells you to suppress that speech and move on. Remember three things. First, the First Amendment exists precisely to protect the speech that others find objectionable. If speech were universally popular, it would not need constitutional protection. Second, the role of the school administrator is not to insulate students from controversial ideas, but to create an environment in which those ideas can be engaged safely and thoughtfully. And third, every time you silence speech because of audience hostility, you establish a precedent that erodes the expressive freedoms of everyone in your school community, including your own. Counterspeech is the constitutional answer to objectionable expression. The heckler's veto is the unconstitutional shortcut. Your job as school administrators is to protect the former, which is the counterspeech, and resist the latter, which is the heckler's veto, even when the political and organizational cost of doing so are substantial. That is the challenge school administrators need to face. It has never been easy. It is not supposed to be.